Okay, so today I wanted to keep talking about legal issues. Those of you who heard them obviously heard from Kelly and Carlene, who laid out in great detail the rules of libel, and then in extremely brief detail the rules of privacy. Let me back up, though, and sort of talk about these less in the purely legal context that the two of them were talking about, and more in the context that we're here to talk about, which is that of ethics and journalistic ethics specifically. And let me just then sort of remind you, as I have several times, that the first sort of guiding ethical responsibility of any journalist is to uncover and report news, information, the truth. The law doesn't command that. I mean, you can satisfy the law by never writing a story. So in that sense, the law sets parameters of the work of journalism. It sometimes limits a journalist's ability to get a piece of information or report a piece of information, and sometimes it assists in getting a piece of information and reporting. So it can either help or hinder the journalistic obligation. But no matter what, the journalistic obligation doesn't go away. So the rules of law are important to understand. They're certainly important to understand to keep from getting in trouble or to get out of trouble once you're in it. But the rules of law don't in and of themselves set the rules of journalism or the rules of ethics. In practice, the law obviously circumscribes certain kinds of behavior that would make it easier to get information. I mean, you cannot break into a building and steal someone's files, tempting though it would be. You can't threaten a source with harm, and believe me, that's occurred to me a lot of times. That would make it easier to get information if you could threaten sources, if you could break into buildings. You can't bribe people for information. Now, I will say there are some news organizations that actually take that somewhat differently. A lot of the tabloids pay for information. They don't consider it bribery, but again, there are legal limits to how far you can go to get a piece of information, and where the law prohibits it, it's difficult journalistically to go there. Remember back to the Food Lion case for a moment. In Food Lion, those journalists were not charged with libel. There was no allegation that the story was untrue. What they were accused of is breaking the law in other ways. They were accused of trespassing in the building, et cetera. And remember the Fourth Circuit opinion that I read to you from in this class on Food Lion specifically said that the First Amendment does not protect journalists from prosecution of what I think it's referred to as run-of-the-mill torts. So as I said to you in class a couple days ago or a few weeks ago, if you see a source across the street and you desperately want to talk to that person and you jaywalk to get to that person, the First Amendment doesn't protect your right to jaywalk. It may protect the information that you get once you've interviewed the source, but you can't break the law in sort of routine ways and expect that the First Amendment will let you do it. This comes up, by the way, quite a bit in the reporting on marijuana clinics here in LA. A number of our columnists, too many, frankly, at the paper, have written columns about going and getting a medical marijuana card and then going and buying marijuana with it. Well, if you lie to get the medical marijuana card or you break the law, you could be prosecuted for it. And so that's an issue for those columns. As far as I know, no columnist has been prosecuted for it. It's a pretty laxly enforced law, obviously. But in general, the principle is that the law won't protect you, even in the pursuit of a First Amendment protected activity, the law won't protect you from prosecution for routine violations. There are a couple of places where I will argue at the end of the class, or if we don't get to it first thing next week, where I would argue something that Kelly and Carlene would not argue for you, which is that there are sometimes where I think that the command of journalism is so strong that it warrants breaking the law and risking the consequences for it. Now, we'll get into more about what laws are worth breaking and what journalism is worth breaking the law for, but let me just set that aside for the moment and just offer that as food for thought. Before that, let me talk about, what I want to talk about principally today is the intersection of legal limits and journalistic ethics in 4 areas. Libel, privacy, open government, and news gathering. So let me just take those one at a time. Libel first, the one you heard. I'm sorry, yes. I'm sorry. Libel, privacy, open government, and news gathering, reporting. And by the way, feel free to interject questions at any time, obviously, as we always do. I want to talk first about libel, even though it's the one you've heard the most about. It's the one that most regularly comes into play in journalism. Libel and privacy are the 2 issues that we sort of are most concerned with generally. And so to talk about libel, let me talk about New York Times versus Sullivan, because all libel grows out of New York Times versus Sullivan, all libel law. You've, I hope, read the case by now, but let me go back through it. I think it's worth treating these cases not just as law, but also as in terms of the specific facts that brought them to the court. And they are these in terms of New York Times versus Sullivan. On March 29th of 1960, the New York Times ran an ad. It ran under the headline, "Heed Their Rising Voices." And it was taken out by a group of civil rights organizations. And it included discussion of student protests. It said that the student protests in the South had been confronted by, quote, "an unprecedented wave of terror," and it asked readers to contribute to the efforts of these student protesters and also to Martin Luther King's legal defense fund. He was facing a perjury charge at the time. The ad then goes on to describe the situation in Alabama and in the South. It describes an incident where students were said to have been singing "My Country 'Tis of Thee." They were said in the ad to have been expelled from their school because they protested at the Alabama state capitol. The same ad said that truckloads of police, quote unquote, had ringed, quote unquote again, the Alabama State College campus, that students who had tried to register for classes, black students, found, quote, "their dining hall was padlocked in an attempt to starve them into submission." That's another quote. It also said that King specifically needed help for his legal defense because he'd been arrested 7 times. This was offered as evidence of the sort of persecution of King during the civil rights movement. All of those facts were wrong. They did not sing "My Country 'Tis of Thee," they sang the national anthem. They were expelled, but they were from their college, but they were expelled for a protest at a lunch counter. I think it was in Birmingham or Montgomery, not at the state capitol. The dining hall had been closed, but it was not padlocked. The campus was never ringed by police. There were many police who were dispatched to the campus, but there was never literally a ring around the campus. And King had been arrested 4 times, not 7 times. Now, that's kind of chicken shit errors. None of those change your fundamental sense of what's going on here. The fundamental point of this ad is correct. Students are protesting. They are being arrested for it. They are being expelled for it. King is being repeatedly arrested. There is a war going on, a civil, peaceful and largely, but a war going on over civil rights in the South. Unfortunately, the ad includes errors. So now comes one L.B. Sullivan. He was one of 3 commissioners in Montgomery. The commission in Montgomery oversaw its police department. He's not named in the ad, which is important. And if you'll recall, Kelly saying here on Tuesday, there's one of the rules of libel, and I'll talk about them in more detail in a minute, is the so-called of and concerning rule. Can you show as a plaintiff that the objectionable material is of and concerning you? I can't sue because my son is libeled. I can't sue because a friend is libeled. I have to show that in order to bring a libel claim successfully, I have to show that I've been libeled. So the first thing Sullivan has to do is demonstrate that this ad is of and concerning him. And if you'll recall again from the other day, there's an absolute rule, oddly, that grows out of this. It wasn't in place at the time, the so-called rule of 25. That if the group that's being described is fewer than 25 people, you can say that you're identified. And Sullivan argued, I'm identifiable because there's only 3 commissioners who oversee the police department. I'm known to be one of them, so this is of and concerning me. Sullivan, importantly, did not demonstrate any damage to his reputation. And again, when we talk about the rules of libel, one of the things we'll talk about is that you have to show damage generally. In fact, one could argue, that this helped his reputation in Montgomery, Alabama I think the events took place in 59 or 60. So in an odd way, he fails on a sort of basic level in terms of bringing a claim, but the juries and judges of Alabama were in no mood to quibble about this stuff. They were eager to rule on behalf of Sullivan in this case, and they did. They awarded him $500,000, which is a lot of money in 1960, or 1959. I forget when the case actually went to trial. I guess it was in 60 or 61 probably. And not only is it a lot of money, but because Sullivan was successful, then many other plaintiffs started bringing cases in Alabama, recognizing that they would get, thoughtful treatment, generous treatment. By the time the United States Supreme Court heard New York Times versus Sullivan, there were 11 cases pending in Alabama, and they sought a total of $5.6 million against the New York Times. The New York Times, that's a lot of money in 1960, and the New York Times' response was to pull all its reporters out of the state for fear of generating more libel claims. That is victory in civil rights terms in this case. Alabama has now done what it set out to do, which was to stop the New York Times from reporting on the civil rights movement in Alabama. The Supreme Court knew that. The Supreme Court, by 1960, 61, when this case comes to them, they had already been hearing civil rights cases since, even before Brown versus Board, but certainly since Brown versus Board, which is 1954. The court had been really actively trying to protect the vitality of the civil rights movement. So one of the things that's really interesting about this case, and I can go on all day about it and I won't, but is that it is now stands as one of the seminal cases in the evolution of First Amendment law and, in fact, journalistic ethics because of its implications for libel. But the court saw it really mostly as a civil rights case, not as a First Amendment case. It obviously has elements of both. So, it's 1964 that this case actually comes to the court for review, maybe late 63, early 64. Earl Warren, who's I've written a lot about, was then at the time chairing the Warren Commission, which was the commission that was investigating the death of President Kennedy. He assigned this case to William Brennan, who is Warren's best friend on the court and the court's kind of First Amendment doctrinalist. Brennan went through 7 drafts of an opinion in this case, and eventually he wrote an entirely new federal rule to govern cases like this, and I'll read it to you. It says, the constitutional guarantees require, we think, a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. That is, with the knowledge that it was false or with reckless disregard of whether it was false or not. Okay, so let me sort of unpack that statement a little bit. They're articulating a new federal rule, and that rule prohibits a public official, later cases will expand that to public figure, which is how celebrities and other well-known people become wrapped in on the same language, will prevent a public official / figure from recovering damages for a defamatory falsehood. That's a falsehood, a statement that is false and that hurts one's reputation, a defamatory falsehood, relating to his official conduct. That's an interesting qualifier on this that later gets sort of washed out too, unless he proves that the statement was made with actual malice. And they define actual malice as either knowing that it was false when you publish it, or being so reckless in your pursuit of the information that you publish it without real knowledge of whether it was false or not. That is essentially the rule of libel as it stands today, although, as I say, it's been amended it's been expanded, but that notion of actual malice being the standard for public figures stands today. I'll just add, and I think I've alluded to this earlier in this course, but there's an interesting little epilogue to this as a legal matter, which is that generally what the court does is when it articulates a new rule, is it will send it back to the lower courts to now hear the case and try to apply the rule. The Supreme Court, however, is not stupid, or not generally stupid, and they knew what would happen here. If they sent this back to Alabama courts, the Alabama courts would have applied this test, they would have ruled that Sullivan met it, and they would have awarded him his money. And it would have come all the way back to the United States Supreme Court, and potentially for 4 or 5 years, the New York Times would not have been reporting on the civil rights movement in Alabama. That, again, that was victory in civil rights terms for Sullivan and those who brought this case. So the court did something that it probably shouldn't do, but did in this case, is it said, we deem that considerations of effective judicial administration require us to review the evidence in the present record to determine whether it could constitutionally support a judgment for the respondent. So they went back through the trial record. They said, we've articulated a new rule. We've decided that you can't meet it. Case dismissed. That's sort of Supreme Court for screw you. And that was the end of it. That's the end of New York Times versus Sullivan. So what we're left with at the end of New York Times versus Sullivan is a quite concise and quite clear set of rules for what is going to constitute, what's going to be required to bring a successful libel claim if you are a public official, later a public figure. And the things you're going to have to show are those that Kelly and Carlene explained to you the other day. You're going to have to prove that there's been a false statement made about you, that it is not a statement of opinion, but one of fact, that it hurts your reputation, it's defamatory, and that it is of or concerning you, that it's not about someone else. So then apply that test to Sullivan. That's what the court did in New York Times versus Sullivan. And you can see why he doesn't make the threshold that the court has now articulated. There are, in fact, false statements throughout the ad. As I mentioned, there are a bunch of errors in the ad. Are they defamatory to him? Hard to see how they would be. Possibly, I mean, certainly the question of whether they sang the national anthem or My Country 'Tis of Thee is not defamatory in any way to Sullivan. Truckloads of police are said to have ringed the campus. The falsehood in that statement might actually defame Sullivan, although, as I said at the outset, it's difficult to imagine. He didn't show any damages, and in fact, the defense could well have argued that these helped his reputation in Montgomery, Alabama in those days and didn't hurt them. It's certainly true that it was of or concerning him. I think he could easily have met that standard. There were, as I say, only 3 commissioners in Montgomery, and he probably could have met that test. But most importantly, Sullivan could not have shown, did not show, and presumably could not have shown that these statements were made with malice or with reckless disregard of the truth. They were brought as an ad to the New York Times. They were read, as all ads, and we are, as newspapers, responsible for the advertising we carry. But if there were errors, they were undoubtedly innocent errors brought to the New York Times, and they did not bear on the substance of the case. So Sullivan may have been able to show, if he had gotten the new trial in the Alabama courts, he probably could have shown that it was of or concerning him. He could have shown false statements. He would have had difficulty showing that they were defamatory in the terms of the time. He would have had almost no ability to show that they were made maliciously, though. So he failed. He lost his case. And he left us with the rules now of New York Times versus Sullivan, again, with some amendment over the years. So those are, in legal terms, and those are the terms you heard about the other day, that's what New York Times versus Sullivan means. In ethical terms, it's complicated, I think, for journalism. It does several things that affect our ability to uncover and report the truth. First of all, it does what it was intended to do, which is protect an aggressive press. It allows you, as a reporter, to make errors and not pay a judgment for them, as long as they're innocent errors. If you're out to get someone and you make an error, then you're in trouble because you violated the malice standard. If you're careless, reckless, I mean, reckless is an interesting word. It doesn't just mean careless. It means beyond careless. It means proceeding wantonly without trying to hear whether there's another side or whether you might be wrong. So it's sort of super careless. If you do so, then you are in jeopardy of violating New York Times versus Sullivan. You're in jeopardy of a successful libel claim being brought against you. But that's a hard standard. And there are very, very few libel cases today that succeed. As Kelly, I think, said the other day, very few of them go to juries. When they do go to juries, juries are often sympathetic to libel plaintiffs, but then they're often overturned or reduced on appeal. So as a legal matter, New York Times versus Sullivan has set up a threshold that is quite easy, generally, for a media lawyer to defeat a plaintiff on. But again, I'm trying to zero in on the ethics issues of this. There are 2 ways in which it really gets into the ethics of journalism. And beyond protecting an aggressive journalism, which is an important one, it allows now, because it establishes a standard that goes to the state of mind of the reporters and editors who are working on a story, because they have to show that once you've shown that there are falsehoods and that they're defamatory, now you're at the stage of trying to determine whether those who did it recklessly or maliciously. So now a plaintiff gets to inquire as to why you did something as a reporter or as an editor. So judges and juries now get licensed to look at stuff that might give a sense of your state of mind. Your notes become available to a plaintiff. Your conversations with other people. You go home at the end of the day and have friends over for dinner, and you're a reporter and you're writing a story, and you say, man, I have got the biggest crook you've ever seen in my gun sights, and I'm going to write a story that takes him out. Well, those people can now be deposed and asked, did you actually say that to them? If you said it, that's evidence of malice. So now there's a whole part of your life that is now subject to scrutiny because New York Times versus Sullivan allows inquiry if you can meet the other thresholds, the falsehood and the defamation thresholds. It now allows this inquiry into your state of mind. That's a tough business, especially given that the press wants to maintain itself as being a sort of separate and constitutionally protected set of institutions. Now the law, in the form of plaintiffs, are going to be allowed to inquire into it. So it creates, and also makes, by the way, litigation on these issues very expensive. But again, on the ethics question, now your ethics as a reporter are really subject to judicial review. And that's an uncomfortable place to be, let me tell you. The other thing it does for the ethics of journalism, I think, is that it sanctions mistakes. Something that, ethically, you have an obligation to try to be right, that your stories must be accurate. New York Times versus Sullivan says you can be a little bit inaccurate. You can make certain mistakes, and we'll protect you. I mean, we'll particularly protect you if you happen to be associated with the civil rights movement in 1960. But in general, the law, the Constitution, will protect your right to make mistakes. And we the court now, think that it's important that we do. They don't like substandard reporting any more than anyone likes substandard reporting. But their view is that if you don't protect the ability of the press to make certain innocent mistakes, that you'll squelch so much investigative reporting that the country will suffer the consequence. But as an ethics matter, it's important to remember that just because the Constitution allows you to make mistakes and not get sued for it, doesn't mean that your journalistic practices or your personal ethics should allow you to. You continue to have an obligation to be better than what New York Times versus Sullivan allows you to be. There is a famous moment. Edward Bennett Williams was the lawyer for the Washington Post for many years. And he was asked years later whether Sullivan was, quote unquote, a license to lie. And he said, yes, that's right. It is, in fact, a license to lie. I mean, really what it is it's a license to err, a license to make mistakes. But the court will protect certain material that isn't right. And so I guess the thing I would want to add chiefly to the conversation you heard the other day about the law of Sullivan and the law that I've just described here is that in addition to the protections that Sullivan offers and that the rules of libel offer, is that journalists need to be better than that. That ethics requires something higher than what the law allows. Let me pause there because that's a lot to sort of digest. Any questions or thoughts on Sullivan or libel? Anyone? Yeah, sure.
Just on Sullivan, ethically, what's the difference between a newspaper reporting an ad, that ad they paid to put that ad into the newspaper, rather than a reporter writing the same thing?
Well, Sullivan makes no distinction between the reporting that appears in a paper and the advertising that appears in a paper. And most people, I think, don't know that New York Times versus Sullivan was about an ad. But if they had actually reached, let's say they'd gone back to trial in Alabama, the very thing that the court kept them from doing, one of the issues would have been, all right, so there would have been a whole set of depositions taken about the person who paid for the ad or solicited the ad, the person who wrote the ad copy. Were those people, did they have some kind of malice towards Sullivan? Did they, were they out to get him in some way? I mean, there would have been a whole inquiry into that, and it would have been a different inquiry than if a reporter had written the story. Because if the reporter had written it, that would have been an inquiry within the news gathering operation in the New York Times. Instead, this would have gone through the ad department. Would it have come out differently? Hard to say. And as I say, the key thing here is that the court just didn't want to suffer that whole process. But the really important point is that a newspaper or any other media organization is responsible for the potential libel of advertising that appears in it, which is hard because a lot of times we're not writing that material. Somebody else is writing that material, so it puts a special obligation on a news organization to check it out. Yes?
So when you said that the reporter's work is subject to judicial review, how far can that go? Because within that, harm maybe other rights that they had, like in order to prove that something was made maliciously, can they find out a source? Can they do, doesn't that?
You raise a really interesting question. The question is, how far can a judicial inquiry go into a reporter's malice or alleged malice? Often the worst case scenario for a reporter is to be put in a position where the only way that you can show that you were doing your best as a reporter is to reveal a confidential source. Because imagine that you have something in a story that says, ex-commissioner was widely regarded to be a drunk. Says, a fellow member of the city council, whatever. So it's attributed to someone. But it's anonymous. It's someone who prefers to remain anonymous. Your way to get out of the malice claim would be to say, I accurately relied upon someone who really knew this, someone who said he saw him drunk in a meeting or whatever. I had real information here. And then the court will say, well, who is it? Can't tell you, it's an anonymous source. And then the court will say, well, you've got to choose. You either present to me someone who can show that you did not act maliciously, or you lose. So now you're in a situation of either losing a libel claim or outing a source. And if you out the source, by the way, then the source is going to sue you for outing the source. So, it gets really messy really fast. But the answer to your question is there's broad latitude for a plaintiff to inquire into your motives under New York Times versus Sullivan, because they have every right to. If you're acting maliciously or recklessly, they win. And if you can't show that you weren't, you lose. So that's something with profound legal implications, obviously, but also with very significant ethics implications for how you go about writing a story and how you're going to be able to show later that you did so honestly and not maliciously or recklessly. Anybody else? All right, well, let me talk a little bit about privacy, which you heard much less about the other day. In a sense, privacy is like anti-libel. It's strange because it's odd. Privacy is much harder one for working journalists to accept as a claim, because at least you get as a journalist that if you made a bad mistake that you're going to pay some consequence for it, whether that's professional or legal or personal or whatever. Privacy has to do with stuff that's true. So it's a little bit harder to grasp as why it should be actionable. But the basic elements of a privacy claim, and Kelly kicked these off in about 90 seconds the other day, it's the revelation of a private fact that is highly offensive and that would cause the subject harm, and where the issue is not of such newsworthiness that it overcomes those other privacy implications. So again, let me break that down. A private fact. What is a private fact? A private fact is a fact that is known presumably only to you or to those most intimate with you. Sexual orientation, sexual habits, drug use, political affiliation, past indiscretions. If you were punished as a kid for cheating on a test, or you got into a scuffle with a police officer, didn't get arrested, but there was an incident. If you set a forest fire, if you did bad things. Now, I should say, bad things that didn't result in an arrest. If you get arrested, an arrest is a public act, and your private issue is now a public issue, and you're screwed. So the revelation of an arrest is not considered a disclosure of a private fact. But the other things that you might get arrested for, if you didn't get arrested, might in fact be things you would treat as private. Now, a subject can make a private act into a public fact in a variety of ways. There's a 1986 case in California where there was something called the Exotic Erotic Ball. And people went and dressed up in erotic costumes. And some of them were pictured. And they sued because they said their privacy was violated. It was embarrassing to them. The court said, no, that's no good. If you go to an event with hundreds of people, you can't then expect that you have some privacy interest that can still be protected. So you've now transformed what you might have thought of as a private event into a public act, and the press can report on it. The one that we all talked about at some length a few weeks back, Oliver Sipple. Oliver Sipple, as you'll recall, sued the San Francisco Chronicle for reporting that he was gay. The court ruled, no, this is something you disclosed to hundreds of people in different ways here in San Francisco. Lots of people know it. You're at a gay bar. You're this or that. True, he had not told his parents, but the court said if you've told that many people, if you've lived that public a life, you can't then turn around and claim it back as a private fact. So there are some things that we as human beings might consider private to our lives, but the courts and journalists would have the right to report on, and courts would protect them. Highly offensive, whether a fact is highly offensive, is also something that is subject to reconsideration over time. Sexual orientation, as Kelly talked about the other day. Sexual orientation was, to say that someone was gay, was once considered the revelation of a private fact and therefore actionable as an invasion of privacy. Today, that's not true some places, and it is true others. It's not true for some people, and it is for others. It may be, you know, I mean, as we were talking about the other day, it may be that the suggestion that Tom Cruise is gay might create an action by him, because it might damage his, it might be defamatory to him to be called gay, given his career and the kinds of roles he plays. And yet, for most people, it probably wouldn't. And certainly in California, it wouldn't. But it might also cause more damage to one's reputation in certain parts of the country than in others. So different states treat this differently, and it may be applied to different people differently. The question is, can you show somehow that that is highly offensive, that the disclosure of this fact that other people would consider it highly offensive? Same evolution has been underway with respect to political affiliation. It was once not only highly offensive, but quite devastating to be called a communist. You would lose a job, you would have lost a job at this university, which once required a loyalty oath. In fact, I think there still is a UCLA loyalty oath, but that's a different subject. But it would have cost you a job in most public employment in this country, and much private employment too, certainly in the movie industry, if you'd been disclosed to be a communist. So you might argue that that was the disclosure, if that had happened to you, you would argue that that was the disclosure of a private fact that was offensive to others and that caused you damage. Personal habits, all range of issues of whether they would be considered private or not. Would drug use be private? Well, it might be if you only did it in your home, but it might not be if you were at a party. Sexual partners, adultery, there are various things that the disclosure of those things others would find highly offensive, and therefore it would satisfy one of the claims or one of the standards of a privacy claim. And your personal views. Now, I just mentioned Commissioner Sullivan from Montgomery. If Commissioner Sullivan in Montgomery, Alabama in the 1960s is called a racist, it probably assists his chances of getting reelected. So is that a highly offensive fact to disclose him as a racist? Well, by the standards of Montgomery in that era, probably not. Today, probably yes. So again, these things are kind of part of a larger social context in which what we as a people consider offensive changes over time. And also does not change uniformly. It does not change at the same speed in West Virginia as it does in Los Angeles. Some of these things would be actionable in some parts of the country and not in others. And finally, all of this can be overcome if the subject is of sufficient newsworthiness as to warrant the otherwise what might be considered an invasion of privacy. If you're the President of the United States, you are not going to be able to claim a privacy interest. Bill Clinton might think it is terribly invasive that the press reported extensively on his relationship with Monica Lewinsky. Tough. The more newsworthy you are as a figure, the less privacy protection you can reasonably expect to enjoy. That's the easiest one. President, you're not going to invade the president's privacy with your reporting. But what if you're the judge in the Prop 8 case, who we've talked about before? Is his sexual orientation legitimately a private fact? What about Oliver Sipple? We talked about before. Obviously, he litigated his long time. The court said no, but that's still a kind of close call. And then you can imagine cases that are even harder. You're working for your high school newspaper, and there's some student who's widely known to be sort of the stoner of your school. Can you report that? How public has he made that fact? Is the fact that he might be a kid affected? That's where these kind of decisions get much trickier. And whereas the newsworthiness of the subject sort of comes down in scale, the requirement that the conduct being reported on be public rises. And that's, really, I guess the hard thing about that, and let me just ask you, is who should be the judge of that? Who should judge whether the newsworthiness of a subject is sufficiently high that it overcomes the privacy interests of the people being written or reported on? Does anyone have a thought on that? I mean, yeah.
I don't know, I guess if like in the one case with the lobbyists, like have you written about them? Have they been on the news? I think that's the fair judge to say if you're public or private.
Yeah, I mean, I think that's clearly part of it, is have you been in the news? Newsworthiness is, are you someone who's regularly in the news? Have you ever been in the news before? Vicky Eisman, as far as I know, had never been named in the New York Times until that story. Yes, in the back. Well, in both is the answer. I mean, in the sense of Oliver Sipple, for instance, there's no newsworthiness to him as a person. He didn't, and up until that moment that he blocks the gun from being shot at Gerald Ford, he really hadn't done anything that we would consider newsworthy in a grand scale. But suddenly, he's done something that is intensely newsworthy. So now the question is, do the otherwise what might be argued to be private facts of his life now become all a matter of public record because he's done something of intense newsworthiness? The court obviously in that case ruled that it had, although as I said at the outset, people have long kind of argued over that question. Yeah.
How do all private facts about a person become newsworthy just because they've done some newsworthy event? Like, I don't know how his sexuality is that pertinent to what he did. It's not.
That's also a really good point in the sense that if by doing one newsworthy thing in your life, just suddenly every other thing, does it all get swept in?
Yeah, he's the president, and by the way, he had a drug problem. Okay.
Right, right. I mean, the best argument is that the things that seem relevant to your act would come in. And so, for instance, in the case of Eisman, if she had a relationship with John McCain, and by virtue of that relationship got better deals for her clients, that easily comes in, right? But what about the effect that she, who she dated in college? At some point, you have to, I think as an ethics matter, even if the law doesn't stop you from going forever down this path, your ethics ought to. We can't make every private act of every private person a matter of public record just because they do one public thing. I mean, there's a kind of reasonableness standard here, and I'll actually talk more about that in a minute. But yes, did you have something?
Well, I was just gonna sure, ethics should probably stop you, but in the polls that they do about what kind of news stories people want to hear, they'll always say like they're not interested in like the scandalous things, and then they're asked to rate, do you think other people are interested in these scandalous things? And they're, oh yes, everybody's
Right.
interested.
Everybody but me
Which
is interested.
Which is really a better gauge of saying that they are interested. They just don't want to admit that they're interested in the scandal and the whatever it is. So I mean, that's why journalists do it. I mean, because it's. I'm not saying I agree with it. I'm just saying like there's a reason why they put those things into stories because.
Yeah, I mean, one of the this is a little bit off the subject, but it's also important to say. I mean, one of the things that is, I think, terribly dangerous in journalism today is that the internet has provided us with ways of monitoring readership that are sort of disturbing because it's about hits, right? And the fact is, the news analysis of the healthcare bill doesn't get the hits that the pictures of the Oscars do. And so do you turn your reporting to focus on where the audience is, or do you try to move the audience to where the reporting is? And I certainly would argue the latter, but that is not an easy fight. That is something that often pits the business interests of the paper and the journalistic interests of the paper at odds, and that's a whole other conversation, but it's a live one and it's not going away. Yes?
Let's say that, like, a news report gets a tip that a public figure is doing something illegal, and, I guess law enforcement can use articles as justification to obtain warrants, if let's say the person that they're talking about sues them for, libel or invasion of privacy or whatever, does that stop law enforcement agencies from being able to obtain, like, search warrants and things like that?
Well, first of all, I think it would be pretty difficult, at least most of the time, for a law enforcement agency to get a warrant based solely on a news report. Because a news report is by definition hearsay. It means that the law enforcement, just reading the story, the police officer, the detective, the judge, those who would be considering the warrant, can't know if it's true or not. They need to go out and independently investigate it. Now, that said, a lot of investigations get started because of a news report. And if a detective reads something in the paper that says, Marion Barry is smoking crack. I don't know if that appeared in the paper before or after, but in any case, it all happened at some point. Reads that in the paper. Let's say someone is quoted saying, I smoked crack with Marion Barry on Tuesday. there's nothing that stops the detective from going and talking to that person. And if that person says, yeah, that actually, I said that, then that's what the warrant will be based on, probably not on the story itself. But, throughout that whole process, could the subject of that, either the newspaper investigation or the police investigation, object, say that it was a lie? Of course. And that would be true, frankly, whether it was in the paper or not. But if it were in the paper first, it just kind of reverses what would be the normal process. Did you? Yes.
Going back to the original question, I kind of think, as going with what he said, unless it relates to the area that they're like publicly known for, then I don't see why anyone else should know about it. And I feel like it's kind of malicious, actually, to put private stuff that they wouldn't want to know. It doesn't affect what they're doing in the public, like in the public sector.
It is uncomfortable to go too deeply into the lives of people who are only marginally on the subject of news. And this is a hard ethical standard to apply, but if it makes you queasy, you should probably think about it. And as I say, that's very individualized, and it's hard to make a kind of grand ethical observation about that. But there is no doubt but that you could write things about President Clinton that if you wrote them about your neighbor would make you feel like violative, like that you were doing something wrong. How you measure those things, though, and sort of answer to my original question, who makes those judgments? Really, the answer is that reporters and editors have to make those judgments all the time, but that they are always subject to somebody looking over their shoulder. And the legal standard that's going to be applied is, did it offend these principles in the view of a reasonable person? And the fact is that most non-journalists are much more likely to see an invasion of privacy than journalists are. And therefore, it's really incumbent on not all journalists and not all other people, obviously, but it is really incumbent on journalists to imagine how a non-journalist would read it. And as someone said the other day, one way to do that is to imagine that the story is about you. There's a lot of stuff, I hope not too much stuff, but there's a fair amount of stuff that I wouldn't want reported on in the newspaper, And therefore, if I were going to report on those things like that about other people, I should need to ask myself, is that fair? Forget the question for a moment of whether the law would let me do it, and just ask, does it feel like I'm doing something to someone else that if they did to me, I would feel violated by? And of course, the problem is that people will decide that differently. But what you should realize is that juries will decide it harshly. Juries do not like journalists who poke around in other people's business, or what they perceive as poking around in other people's business. That's one of the reasons why, as Kelly said the other day, this is true of libel too, by the way. Libel cases that go to juries are not generally sympathetic to journalists in libel cases. Damned if I know why, but the fact is that's why most cases that media organizations win on libel or privacy claims are ones that are decided by a judge either who won't let it go to a jury or by an appellate court that overturns a jury. Juries are not friendly in these kinds of circumstances. Yeah.
I think it also really depends on if the person voluntarily put themselves into the public light or if
Clearly.
they happen to.
Yeah.
Because for Sippel, it's not like he premeditated that, whereas like a person who decided to be on a reality show, it might not be such a violation of privacy to post their past dating information if they're voluntarily putting themselves into the public.
Good point. And then the sort of ultimate example of that is the person who decides to run for office. That as soon as you run for office, you've clearly said that there's a whole bunch of material that a newspaper wouldn't write about if you weren't a candidate that now might get written about. And that's one of the things that people take a deep breath before running for office is, do you want to open up your life that way? The reality show example is a good one in the sense that it's not quite the public act of running for office, but it is a kind of public exposure, And as I mentioned with Sullivan, Sullivan initially only applied to public officials in their public conduct. Over time, that's got our sense of what constitutes public has gotten bigger and bigger, so that now it covers public figures. It would cover people on reality shows, no doubt, whereas initially it would not have. Thankfully, there were no reality shows in the day, but the language of it would not have covered it even if they'd existed. Yes?
Kind of going off of your point, we see, reality shows are like the big thing on TV. And
So I hear.
yeah. And I have to wonder, where do you draw the line of when this person is no longer a public figure?
Oh, that's a good question, too. A really interesting question, and I wish Kelly and Carlene were here to answer it more precisely than I can, but what happens to a very old private fact? So let's say you are, suspended from school for, smoking in your dorm or cheating on a test or something. 25 years later, has that receded into becoming a private fact again? Does it become a public fact again if you run for office? Does it become a public fact if you appear on a reality show? Those are really hard questions to answer, and I don't have a bright line answer for you, except to say that as with all these things, a certain reasonableness ought to apply, that we ought not permanently be forced to answer for the campfire that we set as a 9-year-old that burned down the neighbor's fence. I mean, at some point, that ought to be allowed to recede into your past. Journalism is not notoriously good at allowing facts to recede into people's past. In general, I guess I would say that the acts of children ought to be forgivable at some point. I mean, forget the child murderer, the Menendez brothers are going to be remembered for that for a long time. But I'll tell you, as I was a third grader or something, and I set a fire in the alley behind my house. It did not burn down. It did not burn down anyone's fence. But should I? Now I've now probably just resuscitated that into my public life, which I'll talk to you about that afterwards. So, but at some point, am I going to be forever held responsible for that, or does the fact that I was grounded for 2 weeks as a third grader suffice? I think you need to approach the subjects of your reporting with some sensitivity to that. That at some level, especially people's minor bad acts, can't haunt them forever, just as a reasonable matter. So if you're writing a profile of a inventor of a new device that's getting, they've just sold it and it's doing some important good thing, really, their life as an elementary school student probably is not relevant. Now, if as an elementary school student, they blew up their garage making an invention that turned out to lead to this one, well, it might be, and it might be sort of fun. But I would just approach it with a humanity to it. Again, I think, this is an issue it's in a different way for obituaries. Who's featured in an obituary and what goes in it? By the way, if any of you have the chance, last Sunday's New York Times on front page has an obituary of Al Haig by Tim Weiner that is really worth reading. It's really one of the best obits I've ever read. But that's a big issue in obits, is how far back do you go and what's relevant? There's part of the reason I recommend that one to you is he notes that Al Haig was famous for saying, "I'm in control," during the White House episode when Reagan was shot, I think it was. And someone said at the time, that's going to be the third paragraph of his obituary. And so Tim writes it and makes it the third paragraph of his obituary. Would he have liked to have put that incident behind him and not be remembered chiefly for that? Probably. But he did it in the White House in the ultimate public forum. It was a matter of giant public discussion at the time. Tough luck. That haunts you past your death, as is in the case of Al Haig. In other cases with people of lesser importance and incidents of lesser importance, then they probably recede. Yes?
When someone becomes a public figure, do things of their past now become public? Or that's what...
Can.
I know we're talking about, how far do you go back, but at the same time, how important is their life to the public before they became a public?
Well, how about, he's not a perfect example because the Kennedys were such a public family for so long, but Ted Kennedy was involved in a cheating scandal when he was at Harvard. He was not a candidate, not a public official, he was a student when it happened. The fact that I can tell you about it is evidence that attached itself to his public record. I think that if you offer yourself, certainly if you are a United States Senator, a candidate for president, you've opened up a lot of your pre-public life. But again, that's sort of the ultimate, level of public figure. The lesser public figure, the Vicky Eisman, the Oliver Sipple, I think it's much more situational, and you can't assume that everything they did that led up to a brief moment of public fame becomes relevant for a news story or defensible for a news story. Yes.
If things should be relevant for them to be newsworthy and be concerns to something in a public figure's past, how come so many celebrity things like sex tapes? Is that just because it's sensational?
Yeah, well, sex tapes. I don't know. I haven't thought a whole lot about the ethics of sex tapes, to tell you the truth. I suspect that some of these sex tapes, frankly, are not only not intrusive, but are actually intentionally planted in order to generate a certain amount of publicity around people. run down it as a privacy first of all, they're not libelous, right? Presumably they actually depict what are presumed to be depicted, are therefore not slanderous or libelous. They don't hit that standard. They are arguably a privacy issue. There are two people involved, generally, sometimes more. Does that, they have privacy interests too. The celebrities, if the celebrity's not the only person on the tape, what about if the other person releases it? They're on the tape, they're presumed to have given consent, blah, blah. I suspect the reason they don't get litigated, some of them do get litigated and some of them get pulled back off. The reason the others don't get litigated, I suspect, is that they can't really show that it's caused them any harm. That in fact, probably the opposite, that it probably helps them in a kind of perverse professional way, But that said, that's frankly the first time I'm thinking out loud because I have not run through the full ethics inquiry on that. So, yes.
I think something that's also really important to consider that the lawyers on Tuesday really, I feel like, stressed was just the whole fact about the internet now and how the internet kind of raises the standard of what's truly private.
Uh-huh.
And I mean, as far as like having like a private profile on the internet, from what I got from Tuesday, that's not a private thing.
I think anything that anyone puts on the internet, they are asking for it if they later try to claim that they have a privacy interest in it. I think their point is one that's good to heed as a journalist, but it's also good to heed as a person, that you give up the ability to claim that something is private once you've posted it, even in what may seem to you to be just a group of friends, quote unquote friends. There's a lot of privacy waiver when you start putting stuff like that up. Yeah.
Well, I guess my question is with that is where is that line drawn? Because remember we were talking about Facebook and how like things posted on Facebook and other social media aren't necessarily permissible to use
Yeah, right.
So
Good point.
what
Well, there's two different issues. One is the sort of propriety of using information off a social network, and the other is the ability of the person about whom it's used later to claim that it was private. My argument against about being careful in using it in reporting is that it's very difficult to verify. The mere fact that, so-and-so, if you put up on your website today that, someone is a crook, and it's very difficult for me to quote that and rely on it. It would be much more helpful for me to talk to you about it, figure out why you're saying that, talk to the other person, try to verify. There's a level of reporting that just taking it off your Facebook page is pretty near reckless under the standards of Times v. Sullivan. But the different point is, if you put up on your Facebook page, hey, I robbed a bank this afternoon, and then I put in the newspaper, Zach says he robbed a bank this afternoon, you can't come after me and say, hey, I had a privacy interest in that. I only meant for my friends to see it. I didn't mean for the Los Angeles Times to see it. You're going to lose that case because you've disclosed it in a sufficiently public way, in the same way that, not exactly the same way, but in a way like Oliver Sipple had told other people he was gay. If you start telling people something private, then don't be surprised when a newspaper publishes it, and don't think you're going to get money at the back end.
It's an issue of truth.
An issue of, right, it's an issue of truth, and it's an issue of private fact. You've lost your ability to show that a private fact of you has been disclosed if you disclose it.
Could I argue that you didn't know about to take it off?
You could argue it, but I think you're probably going to lose because you've put it up in a place where I can get it, and in not so, if you, well, I don't have a good non-internet example to give, but if you start talking to people or telling people something about yourself, whether you do it electronically, verbally, in passing notes, whatever, you put up a billboard outside your house, you've started to make it a public fact, and you can't then claim it back as a private fact. Yes?
I was gonna say, like, as an example of, like, the whole, like, Facebook thing and, like, privacy is, like, the thing at UCSD, the content cookout, it was, like, sent out over Facebook, like, an invitation to, like,
Oh, yeah?
attend.
Well,
Do you
I don't know this story, no.
Well, I guess, like, since it's, like, Black History Month
Uh-huh.
right
Oh.
now, I think, students at UCSD
I did hear this, yeah.
decided to have, like, a content cookout, and they, like,
Charming.
sent out invitations saying, like, dress code is, like, to be ghetto, and, like, it was, like,
I get
really
it.
offensive.
Yeah,
because,
right.
Like, the Black student population there is, like, really low already and stuff.
Mm-hmm.
And the organizer of the event like sent it out over Facebook. And, like he later took it down, but they said like I was reading like all over the newspapers and stuff that like it was already like cached. I think like they already had a record of it. So.
Yeah. that's a perfect example of, I mean, one of the admonitions here, again, to heed, not just as journalists or potential journalists, but as people, is that it is pretty much impossible to get back something that you've sent out over the internet, to get back in a way that has meaning under the law. That disclosure is disclosure, and if you put up a billboard in front of your house saying, Compton cookout night, here is that, and then you have second thoughts about it 3 hours later, too late, you've done it, and you might this is effectively the same thing. Yes?
Kind of going off what she said, so with the Tiger Woods issue, is that, first of all, ethical for journalists to be, revealing totally private things about him? And then also, I mean, obviously, I don't think he has, taken a case, but is that legal? Because I don't really feel like
He's not going to bring a case. The last thing he wants to do is to talk about this for 5 more years. Yeah, that's a good question. I mean, if this is purely private conduct, the only victims are his family, I suppose, I mean, I think there's there's 2 questions. One is any coverage warranted? And then 2 is the amount of coverage warranted? And I guess I would argue that he is so consummately public and so giant in the world of our culture that he's at that standard where he might as well be president of the United States in terms of how we treat him. And in some ways, his cultural impact is probably as great as some presidents. And I also have to admit to not feeling very sorry for him. So, but yeah, I mean, does that justify, infinite coverage of him? I would say no, and I'm sort of tired of it already, and I think a lot of people are. That's not a purely articulable ethical standard either. But, Michael Jackson made some of the same claims, I mean, his involved children, so there was a legal issue at stake too. But, at some point, I think you rise to a kind of stratospheric level in society in terms of your public persona, that pretty much anything you do is fair game. And that doesn't mean that we should write about this on the front page for the rest of our lives. I mean, the McCourts, at Dodger Stadium, or with the Dodgers, are undergoing a similar thing, that they're getting divorced. It's a sad thing. It's, but the Dodgers, they own the Dodgers, and so their divorce is going to get covered in a way that divorces don't generally. And they didn't have to buy the Dodgers. They didn't have to get divorced, but that's more their business. Once you buy the Dodgers, the kinds of stuff that you do, that other people do that doesn't get covered, are unfortunately going to get covered. You win enough Masters, same thing happens.
Just directly related to that, as far as the Tiger Woods coverage goes, when you were revealing his text messages from his phone records, would that be considered going too far?
He sent them to someone else, and that's who's revealing them. So they're their messages too. Yeah, you're right. I mean, if we were just eavesdropping on his phone conversations, then that would be both an ethics problem and a legal problem. But if he sends his messages to someone else and they own them, then they can reveal them. And I'm assuming in every instance that that's what's happening. Let me move on. I know we could talk about this a lot, but I want to cover these other areas quickly. The third of these sort of 4 areas that I wanted to touch on today is open government. The openness of our government is prescribed by law. And it derives from a principle, which is the idea of the consent of the governed, that you cannot sort of give your consent or sustain your consent to be governed by our government without knowledge of what the government is. We're a public democracy. And there are laws that require that of government. There are 3 major ones that would apply to someone if you were reporting from California. The Freedom of Information Act, which is a federal statute. The Freedom of Information Act, which was enacted after Watergate in response to what were perceived as the secrecy of the government, allows for you to file for government records and receive them as long as they are public. There are certain exceptions, and I'll talk about them in a minute. There's also the California Public Records Act, which allows you to, through a similar process, to request state records from the government, state or local government records. And then there's something called the California Open Meetings Law, also known as the Brown Act, which requires that meetings generally be open. I'm sorry, yes, the three statutes, the Freedom of Information Act, known as FOIA, F-O-I-A, Freedom of Information Act, is the federal statute. And then the 2 relevant California ones that I'll mention today, the California Public Records Act, also known as the CPRA, sorry, these are not terribly clever acronyms, but, and then the California Open Meetings Law, also known as the Brown Act, named for somebody Brown who passed it. All of those contain some exceptions to a completely open government. We do not, as a society, pursue the notion that every act of our public government should be publicly open. That's a debatable issue, but that's a fact. But all of those acts presume that the vast majority of the work of a democratic government should be subject to review by the people who are governed by it. But let me quickly tick off what are some of the exceptions to that notion that we live in a public government. Some we've already talked about in this class that justify either privacy or secrecy, depending on the issue. A threat from the nation's enemies, classification, top secret documents. Presumably, it was not in the interests of American democracy to publish the plans for the atomic bomb as they were being developed in World War II. To do so, obviously, gives them to those who you're trying to keep it from, frankly, for those you're trying to bomb. There are, clear secrecy, classification secrecy, top secret information, et cetera. There's a protection that applies both federally and in local statutes to people who are under investigation, ongoing investigations. There's a couple reasons for that. The most obvious being that if you released material about an ongoing investigation, people who were subject to that investigation could flee, they could arm themselves, they could be prepared to retaliate in ways that could put police officers in danger or jeopardize investigations. There's also one that's talked about less, but that's important too, which is that it can subject people who are under investigation to unfair scrutiny at a time when they're not guilty of anything. Police investigate a lot of people who don't ever get charged with anything. In most instances, it would be damaging to their privacy. There could be private facts disclosed to reveal the facts of a police investigation. So that's generally regarded as an exception to open government. The handling of lawsuits. Public agencies are sued just like anybody else, and they have a right to consult with their lawyers and devise a legal strategy. That's good not just for the agency, but for taxpayers who are on the hook when public agencies are sued. So we generally allow them to go into what's called closed session to discuss litigation issues. There are some contracting issues that are also off limits. And again, for obvious reasons. Public agencies will often take bids to do a project, to do work. And you want those bids. If those bids are public, then people will use them. The first bid will come in, and the next one will be 1 penny less, and the next will be 1 penny less than that. And it behooves the public to have those bids all submitted secretly so that you get the best possible bid. You get the lowest price for the work you're asking to have done. So there's a public interest in that. Having said that about all those exceptions to the public records principle, let me just say that public records and public meetings principle, it also, all efforts by the government to make information secret or unavailable should be monitored by a vigilant press. That doesn't mean that all information, I'm not trying to argue that every document that crosses every public official's desk should be faxed to the Los Angeles Times, although that would be terribly fun. But it's a reminder that these kinds of designations of privacy or secrecy in documents can be abused too. We already talked about the Bay of Pigs and the government's efforts to keep that quiet before it happened, and then the sort of misgivings later when the coverage was sort of scaled back. Similarly, the warrantless surveillance program by the Bush administration. Yes, it was kept private out of some national security interest to keep those who are subject of the surveillance from knowing about it, but it also had an effect on our public discourse. We were denied the opportunity to have a timely debate about warrantless surveillance prior to the Bush reelect. The investigative protection, protecting investigative records. Again, there's a valid reason not to disclose records prematurely, but you should also remember that just right here in Los Angeles, the Los Angeles Police Department historically has engaged in spying on suspected subversives. It spied on political enemies of the department. There was one great case called the PDID case where one of the supervisors in the spying unit was storing all the material in his garage. And I mean, it was a mess. So that the mere fact that the law allows protection of certain material doesn't mean that it's always rightly used, and it deserves scrutiny by the press. Finally, even the issue of litigation, which is one that I think is commonly accepted, that why should a public agency have to talk about its legal strategy in public? To do so is just to invite people to sue you and to win, and the taxpayers are ultimately clearly the losers in that. You don't want your government successfully being sued all the time because the law required them to disclose their strategy to their opponents. But I will also note to you, this is not as well-known a case as the ones I just described, but a few years back there was an issue where the county of Los Angeles, there was a ballot measure that some folks were trying to put on the ballot about protecting county workers from, I think it was either layoffs or cutbacks of one kind or another. The lawyer for the county met with the supervisors in a closed session, closed the press out, and in the closed session told them, you know what, even though I recognize that I have a duty to write the ballot language for this, to approve the ballot language for it, I'm just not going to do it, and I'm going to let them sue me later, and it'll be too late, and we'll win. Well, that was illegal, what he was proposing, and the irony of it is that then when we at the LA Times, a colleague of mine, filed a public records request for the material, they did release it by mistake and then tried to get it back. So they were using not an actual lawsuit, but they were saying, let's do something that will get them to sue us, but in the meantime we'll win. They were using the litigation protection to do that in closed session, to engage in an illegal conversation. So while there are legitimate reasons to protect certain records, that shouldn't make anyone sanguine about it. The mere fact that someone says that's classified, or that's litigation strategy, or that's a contracting matter, or that's an ongoing investigation, isn't the end of the conversation. It's a legitimate basis if it's legitimately used. But journalists have an obligation to question that. Okay, and then finally, and if I have time, I'll talk about breaking the law, but it looks like I may push that on to Tuesday. Let me just say that there's a sort of subordinate set of issues that go with news gathering here. And that is that there is a sort of special exposure to journalists to engage in slander while doing totally well-intentioned reporting. And that, if you'll recall, Kelly was giving the example the other day. First of all, let me just clarify. What slander is it's basically spoken libel. So it's the same elements as libel, but rather than publication of the false fact or the false defamatory factual statement, it's the uttering of that statement. Now, as Kelly said the other day, there was the example she used from some TV show that you can't slander someone to themselves. So the example she used is the doctor was asking a patient on a TV show whether he was gay, and this patient then threatened to sue for slander. Well, you can't do that. You can't slander a person to themselves. But you can imagine how easy it is to slander someone in the course of good faith reporting, in the sense of, let's imagine you're covering the case of Richard Jewell, which we talked about earlier in the course. Richard Jewell is a suspect by the FBI in the Olympic bombing. If you go to his apartment house and you ask the landlord, hey, you heard Richard Jewell, he's a suspect, we think he's the bomber, can you tell us anything about him? Or you go to Vicky Eisman's house, or boss, and say, you know, we hear she had an affair with John McCain. Did this ever come to your attention? Well, you're now disclosing to people who could hurt these folks are facts that may or may not be true. And if they're not true, you've slandered them, even if your purpose is to try to get the truth. So there is a real difficulty in reporting responsibly in certain kinds of cases, because you don't want to, in an effort to get information that would keep you from libeling them, you don't want to slander them in the meantime. Now, as I say, there are ways to do this. You can ask innocent questions. You don't have to assert facts. You don't have to say, you know, we know that Richard Jewell was the bomber. What's your response? That's a lot more dangerous than saying, we're writing about Richard Jewell. Can you tell us what he's like as a tenant? You know, it's just a matter of being careful, but I say it only to remind all of you that there's this kind of other tier of exposure for people who are involved in news gathering. And the same laws that can expose you to difficulty once you've published can also create difficulty in the course of reporting. Now, I don't think I have enough time really to talk about incidents where it may be okay to break the law. So I'll do that on Tuesday. But in the meantime, we have a minute or two left if anyone has questions on any of this. All right. Thank you very much. I'll see you Tuesday. Oh, hey, by the way, there is some reading for next week, and I meant to copy it yesterday and have it for you today.